Okay, everyone, let's get started. Welcome to our first Codex speaker lunch in 2020. And it's a real pleasure to have Professor Julian Nyarko as our first speaker this year, in this decade. You're the first speaker this decade. Professor Nyarko is a brand new member of our Stanford Law School faculty. We're very fortunate because he's actually focusing on how natural language processing, how machine learning, and other data-driven methods can be used to gain deeper insights into the law, specifically into contracts. That's his specialty area. He is, before he came to Stanford, he got an LLM and a PhD from UC Berkeley. And studied at Hamburg University. He was also a fellow at Columbia Law School. So it's really wonderful to have Professor Nyarko here kick off our speaker series. Please join me in welcoming Professor Nyarko.
All right. Thanks, everyone, for being here. Just quickly reading the room. So how many non-law student sort of engineering background people are in the audience? Just so get a sense. Okay, thank you. Thanks, because I just want to know how many comments I make outside of sort of what I would usually talk about. So, this project is called Stickiness and Incomplete Contracts. It's about choice of forum provisions in commercial contracts. Choice of forum provisions, essentially, right? Two companies, let's say, have a contract, and they anticipate that they might have a dispute. Choice of forum provisions say, where are we going to solve that dispute? In what court? Do we use arbitration? And so on and so forth. Okay? And there's something like a conventional wisdom surrounding these choice of forum provisions, which is that they're almost universally adopted. It's not working. Okay, I'll do this. Okay. So I'm putting up 3 quotes here for you. So an associate at White & Case says, omitting a choice of form provision is sloppy work. A senior partner at Arnold Porter says, not including a form selection clause is borderline malpractice. And Bruce Sewell, the former GC of Apple, told me I would be surprised if any of our contracts did not include form selection clauses. Similarly, if you read the literature, in particular the legal literature, there's not a single model, a single theory that would predict parties not to want a choice of forum provision. It's all about what kind of choice of forum provision people want, right? Do we want to go to court? What court is best? Do we want to use arbitration? And so on and so forth. And by the way, a quick remark, please feel free to interrupt me with questions, right? Or put your hands up, and then I will interrupt myself and hear your question. Okay. So we have these statements by practitioners. We have no theoretical model that would predict parties not to want choice of forum provisions. And yet, if we look at the empirical evidence, so this is from a data set I'm going to talk about in a little bit more in detail, choice of forum provisions are not everywhere. What you can see here on the y-axis is among 500,000 contracts, the rate of contracts that have a form selection clause. And on the x-axis, you have years, right? And what you see in orange are form selection clauses referring parties to courts, right? New York over, Delaware, California, Texas, whatever. And then in green, you see arbitration clauses. And if you're interested in arbitration, then you know that usually sort of there's a conventional wisdom that arbitration is really skyrocketing, especially in international contracts. Even if we subset to international contracts, we see a similar trend. Okay, so we have this downwards trend. Only roughly 20% of contracts include arbitration clause in 2000, with a downwards trend. In red, we see a combination. So that is basically asking, does the contract have either a form selection clause referring parties to courts, or an arbitration clause, or both? Okay, and we see that only roughly half of all contracts between 2000 and 2016 have a choice of forum provision. So we have this puzzle in our hand, right? On one hand, everyone says choice of forum provisions are everywhere. On the other hand, the empirical evidence seems to suggest that they're not everywhere. And the question is, what is going on? All right. That's sort of the puzzle I tackle in this paper. I'm going to test the stickiness hypothesis introduced by Julian and Scott in 2012. So they introduced it in the context of what's called the pari passu clause, which is a clause in sovereign bond indentures. Sovereign bond indentures, really complicated financial documents. Pari passu, Latin, obscure, what's going on there. But what they basically did was they went out and asked lawyers, what does the pari passu clause mean? Why do we include them in sovereign bond indentures? And the drafter said, it's history, path dependent. We always do it. And it doesn't have any particular meaning. And then there were a couple of court decisions that, among others, were used to strong-arm Argentina into default because of the pari passu clause. There was a sophisticated law firm, Elliott, that used this pari passu clause to make a legal argument such that it was impossible for Argentina to pay back its debtors, and it had to default its creditors. So the story is the following. We have this pari passu clause, which seems to not mean anything. Then we have this shock to the system. We have this court decisions that say, well, actually, pari passu means something, and it's really important. And so Gulati and Scott went out and asked, okay, do law firms revise their drafts? Do we see a change in the wording of these clauses? Because apparently this is an unintended litigation risk, right? And what they found is that 89% of law firms didn't change their drafts in response to these court decisions. Okay? They go a little bit beyond so basically at its essence, the stickiness hypothesis just says contract drafting is really path dependent. Okay? However you draft a contract in the past has an influence on how you draft a contract in the future. But they go a little bit beyond that, and they say, we actually propose a causal mechanism. We say that law firms induce the path dependence, and in particular, the heavy use of templates. Right? Law firms, when they draft a contract, they never draft from scratch. They use templates. If anything is in the template that is not ideal, then it'll make it into the next contract and into the next contract, and there's not much revision. Okay? The literature as it currently exists has some limitations. So I said pari passu, is Latin. No one really was sure what it means. Sovereign bond indentures, really complicated stuff, right? And so there are certain limitations that raise questions as to how extrapolatable the findings are from the current literature. And so I'm going to test the stickiness hypothesis using a broad set of commercial agreements, and I use form selection clauses. Right? Choice of form provisions are typically 1L material, so most 1Ls have encountered them, know what they mean, and it's sort of really basic stuff in legal education. Okay? And we're going to see whether the stickiness hypothesis can similarly explain why there are so many contracts that do not include a choice of form provision. Okay, what's the data set I'm going to use? I have roughly 500,000 unique contracts. So these contracts, publicly registered companies have to report so-called material contracts to the SEC, and they're all publicly available on EDGAR. Okay? And material contracts are defined as contracts not made in the ordinary course of business. And I scraped all of them between 2000 and 2016. I know all the identifiers for companies and individuals who have ever submitted anything to the SEC. I know a contract type. I know the industry, where companies are incorporated, principal place of business. And I also identified the law firms, and just to give you a brief sense of how this works. So here you can see a notice clause, right? In a contract, a notice clause basically says, if anything goes wrong with the contract, please contact the following people. And I go to the notice clause, and first I scan it for the mentioning of law firm names. So we are going to ignore the first blocks of text here, because this is information from the representatives of the parties. And then once we hit a law firm name, I'm going to extract that block of text, and I'm going to use what's called named entity recognition to identify person names in this block of text. Okay? But because street names and law firm names often have person names in them, I first substitute them with generic strings. And then here I identify Lisa and David as responsible drafters of this contract, this particular contract. Okay? All right, and then I'm going to conduct 3 empirical tests with all that information in hand. So the first test, I'm first going to ask, is the choice whether or not to include a choice of form provision even driven by law firms? Or is it mostly a choice that the client makes, right? Apple says we always want to go to California. If Apple has a policy, right, all of our contracts have to include a choice of form provision referring parties to California, then it's not even, the law firm is not even really part of that rationale. Then I'm going to look at the role of templates for stickiness. How important are templates? Is this really template driven? And lastly, I'm going to look at stickiness and resistance to shocks. But first, right, we have 500,000 agreements. We want to study the choice of form provisions in 500,000 agreements. So how can we find time to read 500,000 contracts? Of course, the answer is that we can't. And here I use a little bit of natural language processing supervised. So for the people in this room that have more training, right, the short version is I'm going to use a bag of words. Of course, there's more complicated stuff, word embeddings, right, and contextualized word embeddings. My view is that complexity is a cost, and sort of the marginal increase in F1 scores was 0.01. So not worth doing, bag of words perfectly fine, but let me walk the others through what I just said, okay? Or something of what I just said in a little bit more detail. So here you can just briefly see how you can approach these NLP problems in general, right? Extracting information from contracts, right? So here's a simple example. This is a short arbitration clause. This is a long arbitration clause. This arbitration clause is neither short nor long. First, we can do simple text pre-processing, right? We can convert everything to lowercase, remove punctuation. We can remove stop words, because stop words, right, they're like the words this is a and so on and so forth. Because stop words, while they can be useful to identify authorship, they kind of act like a fingerprint of authorship sometimes, because the use of stop words is varies by individual and is quite consistent. We usually think that they don't really transport a lot of content of a text. Okay. So we remove stop words, and then we do text pre-processing. So text pre-processing is the removal of morphological affixes. So the words runs and running all become the word run. And again, we think that, right, it's a matter of grammatical convention, whether we say runs or running, or in what particular form a word appears. So we get rid of that in order to sort of decrease the mathematical complexity on the computational complexity of the problem, right? And so once we have done that, we can represent text as a matrix. And that's very simple. So what you can see here is just every row is one word in the corpus, right? And every column represents one clause. And the elements in that matrix just indicate whether a word is present in a clause or not. Okay, so for instance, clause 1, we can look at this column. Okay, clause 1 has the word short, has the word arbitration, and has the word clause. So we have 1, 1, 1, 0, 0. Right? And we do this for every clause, for every paragraph in the contract, and for every paragraph in all 500,000 contracts. Right? And we get this matrix, this bag of word matrix. We can do some reweighting, which is not really important for the purpose here. And then once we are in matrix world, right, we can do math. And so what we can do is then supervise classification. So what I'm doing is I take a random set of 5,000 paragraphs, and I hand code them. 1 if it's a choice of form provision, 0 otherwise. In fact, I do 2 classifiers, 1 for arbitration and 1 for court clauses. But 1 if it's a choice of form provision, 0 otherwise. Okay, I do 5,000 of those. I take 80% of the data and give it to the computer, and say, computer, please learn the association between individual words in the corpus and my hand coding. For instance, learn that if the word arbitration is mentioned, it's more likely that I coded this in arbitration clause. If the word exclusive is mentioned, it's more likely that I coded this form section clause referring parties to courts, because usually it says that they submit to the exclusive or non-exclusive jurisdiction of certain courts. Right? Learn all those probabilities between words and hand coding. And then I take the other 20% of data, the holdout set that the computer has never seen, and I just say, computer, please predict my hand coding. Please predict whether I coded this 1 or 0. And because the computer has never seen the other 20% of data, it's a good way to determine how good the classifier is doing in predicting my hand coding. Okay, and here are some evaluation metrics. So the accuracy, just how many paragraphs do I correctly classify? 99.88%, so it's highly accurate. But the accuracy can be a little bit misleading, right? So if you assume, just imagine there are 1,000 or let's say 1,000 paragraphs. Only one of them is a choice of form provision, right? If I write a classifier that just says everything that I ever encounter is not a choice of form provision, then that classifier will correctly code 999 out of 1,000 clauses, and it will have an accuracy of 99.9%. Right? That's why in information retrieval we also use different metrics to determine how well a classifier does. And if one score of 0.91, I'd say it's high usually. So in many studies on computer science, you're good to go with 0.7, 0.8. There's no magic number that you'll need, but this is sort of a number that you encounter often. It's bounded between 0 and 1. Okay, so and now I have, through coding just 5,000 paragraphs, I can basically identify all choice of form provisions in all contracts. Okay? That's the basic idea. All right, and then we can tackle the first question. Is whether or not a contract includes a choice of form provision a decision that is made by law firms, or is it a decision that is made by the client? And we can just, very basic, look first at descriptive evidence. Okay, so what I'm doing here is I take a company, let's say Apple, and I say, Apple, what is the rate of choice of form provisions in all your contracts? Right, I'll get a number, 0.6, 0.7, 0.8, whatever. And that number I compute for every company. So at the end of the day, every company will have a number associated with it that represents the share of contracts that it reported that include choice of form provisions. I just plot the histogram of these numbers, right? Now, if there are many companies that have a policy, we always refer our disputes to New York, then we should see many companies close to 1, with a share of almost 100% adoption rate, right? But what we instead see is sort of almost this normal distribution around 0.5, meaning most companies sometimes include choice of form provisions and sometimes don't include choice of form provisions. So that tells us there's a lot of variation that's left to explain here, right? So then the question is, can we explain this variation through law firm preferences? So the test that I'm going to do, the way you can think about this is quite simple. So someone's sick, we give them the red pill, they feel good. Someone's sick, we give them the blue placebo pill, they still feel sick. We take the average difference between the two and we get sort of an average treatment effect, right? It's quite simple. And then we know the effectiveness of the red pill. Now we can switch out smileys for contracts, and we can switch out pills for lawyer changes. Okay? So the basic idea is the following. We have a contract that doesn't include a choice of form provision. We know what law firms drafted the contract. We pair it up with another contract. I do exact matching, so both contracts in this pair, same parties, same industry, same type of contract, same year, within 1 year of one another. And so there are pairs in which both law firms are the same, and there are pairs in which both law firms are different. Right? And then the question is, if both law firms in this pair are the same, both law firms for both of these contracts, and the form section clause does not change the presence or absence of a choice of form provision, versus I change the law firms and I have a difference in choice of form provisions, then again I can take the difference here between the upper pair and the lower pair, and I know sort of what the influence of the law firm is on this, on the drafting. Do we have economists in the audience? Do we have other people that are bothered by causality here when I talk like this? Yeah? One? Okay. I do a little bit more to ameliorate concerns of causality, but I'm going to talk more about this maybe during Q&A. So, okay. And then, yeah, we can look at results. So the way to read this is you have horizontal lines here, right? And if 0 is included within this horizontal line, we cannot reject the hypothesis that there's no influence, meaning we don't have good evidence to support the contention that there is an influence. Okay? Now, rows 1, 2, and 3 just say, is the law firm relevant for the presence or absence of a choice of form provision? Rows 4 and 5 ask, is the law firm influential in deciding what type of choice of form provision is in the contract? Meaning conditional on the contract, for instance, referring parties to courts. What's the influence of the law firm in deciding New York over, Delaware, for instance? Okay? And what you can see is a quite consistent influence of the law firm in red. I do the same thing for general counsel, and we have no consistent influence on general counsel. And this seems to suggest that the law firm has an influence and is sort of determinative for whether or not a contract includes a choice of form provision. Yes?
Sorry, what exactly are these variables? Is it like the average of the fixed effects for, sorry, I don't understand.
Maybe you want to look at a regression table. So we have pairs. Remember, one observation is a pair, and then we have an indicator variable telling us whether there's a difference in the law firm for drafting. And our outcome is there a difference between the two pairs in terms of the choice of form provision? So outcome variable?
Yes, I'm sorry. But then, can we go back to the...
I have to go back to this.
Sorry.
No, it's all good. So, yeah?
What are the blue...
What are the blue ones? Those are point estimates, and then 95% confidence intervals. Yeah, sometimes it's too simplistic. Right, and the question is, right, is 0 included in the 95% confidence interval or not? Similar, so if you look at the regression table, you'll have stars here for all of those. But you won't have stars necessarily for the GC influence. Okay? I do a second analysis because sometimes people ask, well, maybe there are choices. Maybe you choose a law firm, right, for a particular reason, and that reason is also connected with your reasons to include choice of form provisions. For instance, you hire a different law firm when you buy a company in California versus New York, and in California you really want a choice of form provision because you want to get out of California, but in New York you might not, right, because you're fine with New York. So what I'm doing here is, in collapse analysis, I think I'll just say this briefly because I think we have time, is I look at law firms that collapsed between 2000 and 2016, and I look at the lawyers that worked at these law firms, and I look at where they went after the collapse of the law firm. And then I basically test a hypothesis which asks, basically, if you're a lawyer, you worked at Morgan Finnegan, you go to a new law firm, you adopt the template of the new law firm, are clients more or less likely to follow you around if you adapt the new template versus if you keep your old template? That's a question I ask, and that is in order to investigate whether clients care at all about, right, whether they choose the law firm at all with respect to whether there's a choice of form provision present in the template or not. Right? And I find no evidence for that. Okay. Now, law firms seem to be influential on, what type of form provision is in there and whether or not there's one in there at all. Now, what's the role of templates? Okay? So, what I'm going to do here is the following. I look at a contract drafted between Wachtell and Skadden. Okay? Then, I'm going to look at all contracts that Wachtell has drafted in the previous year, but not with Skadden on the other side. And I look at all contracts that Skadden has drafted in the previous year, but not with Wachtell on the other side. Okay, and I just ask, I use a fuzzy string matching on the first 10% of the string, and ask, is there a Wachtell contract that looks very much like the present contract between Wachtell and Skadden, but not a Skadden contract that looks a lot like the present contract between Wachtell and Skadden? If there is, then I am pretty sure, I'm very sure, I've looked, I have checked, and I have not found a single case in which this assumption is unreasonable, that the template was provided by Wachtell. Right? Wachtell has used a very similar looking contract in a deal where they were not faced with Skadden on the other side. Right? And Skadden does not have such a contract. Okay? This is how I identify the template, and then I can ask what is the influence of the template on the final agreement between the parties, right? And the situation I have in mind is, for instance, this. Wachtel has always used choice of form provisions historically. Now they get a contract from Skadden that does not include a choice of form provision. Will Wachtel say, hey, wait a minute, there's a gap here? Or will whatever is in the template just sail through into the final agreement? That's the question. Okay? So now I can basically see what the influence of the template is on the final agreement. I can look at this again as regression tables, but perhaps more intuitive. So if we have a contract that, if the previous contract did not include the choice of form provision, we'll have a 16% chance to see one in the final agreement. Okay? If the template does not have a choice of form provision, 16% chance to see one. If the template does have a choice of form provision, then in the final agreement between Skadden and Wachtel, there's a 90% chance to see one, to see a choice of form provision. So that seems to suggest that most of the variation in choice of form provisions seems to be explained just by path dependence, by what Wachtel did in its last deal, or Skadden did in its last deal. Okay? Now there's some variation left to explain. Is that explainable by the preferences of the draft receiver? Okay. If we have a draft, if Wachtel gets, let's assume Wachtel has historically always used choice of form provisions. If Wachtel gets a draft without a choice of form provision, again, 16% chance to see one in the final agreement. If, Wachtel gets a contract without a choice of form provision. If Wachtel has historically used, if Wachtel has historically not used choice of form provisions, there's a 16% chance to see one. If Wachtel has historically used choice of form provisions and now gets a draft without a choice of form provision, we see a 19% chance to see one in the final agreement. Meaning, what Wachtel has done historically when it is a draft receiver does not really matter. This is not statistically significant. Does not seem to matter for whether we see a choice of form provision in the final agreement. Okay? So to summarize, whatever the draft supplier does in the original contract is highly determinative of what is in the final agreement. And what the draft receiver, the preferences of the draft receiver seem to not matter much. Okay? So this is important if you think about sort of distributional advantages of first drafting in contract drafting and all that, right? So you can have the view that it doesn't matter because whatever's in the first draft is up for negotiation. You can just redline everything and send it back, right? But that seems to not be what actually happens in practice. Okay. So stickiness and resistance to shock. So what's going on here? So we have a couple of Supreme Court decisions on default rules and choice of form. And the question is, if the default rules change, so if basically the costs and benefits of not including a form selection clause change, can we incentivize parties to include more choice of form provisions? Okay? We have a couple of Supreme Court decisions. Most of them are towards. What they did is the following. So we used to have a doing business test. Under the doing business test, you could sue a company wherever it does business, basically. So you can sue in many, many jurisdictions. But the Supreme Court said, no, this is too broad. We'll instead go with a essentially at-home test. Meaning you can now only sue companies in their principal place of business.
No longer.
And in their state of incorporation. Okay? Now these are torts cases. But if you look at law firm websites, most law firms say, now in contract drafting, you should really include choice form provisions. Plus, I go in the paper through sort of in more detail. I point out several court decisions that have referenced these Supreme Court decisions in contracts disputes to kick out contracts. And then we have Atlantic Marine, which removed some uncertainty surrounding the enforcement of choice of form provisions. Okay? And basically, one of the questions was whether a choice of form provision is just one part, one element in its balancing test. If a court considers whether to enforce a choice of form provision or whether it's determinative. The court said it's determinative, pretty much, except for special circumstances and so on. Okay, so what we can then do is the following: we have a time series, right? We just look at, again, the share of contracts that include the choice of form provision. And I take this time series, and I go up to the first Supreme Court decision and just say, based on this pre-intervention data, what's your best guess of how the time series develops? Okay? This is what we see in blue and the blue and gray shaded area. And then I compare that to how the time series actually developed. If the Supreme Court decisions had a huge effect, right, we should see that the actual development of the time series is different from what is predicted based on pre-intervention data, right? But we don't see any of that. What we see in terms of the development of time series is exactly what is predicted based on pre-intervention data, which seems to suggest that the Supreme Court decisions that I pointed out had no effect on the consideration whether or not to leave a contractual gap. Okay, so then why does all of this matter, right? So I hope I was able to convince you that sort of the contract stickiness is a widespread characteristic. It pertains to many different types of agreements and for the most fundamental clauses. So there are several sort of academic implications, right? One is that there's often sort of this view that in the law between commercial actors, default rules don't really matter as long as they're default rules, because sophisticated actors will just contract around inefficient default rules, right? So there's no real need to make the law more precise. There's no real need to, at least there's no urgency to really clarify ambiguous or nebulous law between commercial actors. So the Supreme Court is very active in consumer contracts and in torts, for instance. We saw these decisions, but not so much in sort of law as it pertains to commercial actors. And this is basically saying, wait a minute, maybe that assumption, right, leads us astray, and maybe we should also spend at least some capacity that we have in clarifying rules for commercial actors, because the hypothesis that they just draft around inefficient defaults is not true in practice. There are welfare implications if you believe that every contract should have a choice of form provision, as the petitioner suggested. Then, of course, it means that if you don't have a choice of form provision, that's synonymous to sort of burning a small pile of money every time that you have you have that agreement, because it might end up in litigation, and you have to litigate over where to litigate, or even if you bargain in the shadow of the law, right, it can matter where you threaten to sue the other party. And so there can be welfare implications. The last point here is efficiency of clause should not be assumed. So here the basic idea is what we often see in the literature is someone comes up with a theory on what an optimal contract should look like. And then they look at the evidence, contracts between sophisticated actors, and they see sort of a mismatch between theory and empirical evidence, and then they go back and revise the theory in order to make sense of what they can find in the empirical landscape. And this is basically saying, wait a minute, maybe this is not a good idea to approach social science. Maybe we should determine efficiency on its own terms and then not rely on the assumption that whatever we see in these contracts between sophisticated actors is necessarily sort of efficient and optimal distribution of the welfare that is created throughout the contract. Okay, and then I have the last slide. So this is more sort of, what can we do with NLP? And so you might say that choice of form provisions are not the most important clauses in an agreement, and I would agree with you. And so you might say, well, we want to look at other provisions. And of course, you can use a similar methodology to look at other provisions as well. You can do MAC clauses, you can do earn-out provisions, sandbagging provisions. So all of these are sort of traditionally thought of as more important in M&A contracts, for instance, and have more economic significance. I'm not sure I agree. So, for instance, MAC clauses basically say, under what conditions can a buyer walk away from a deal if something happens, let's say, to the stock price of the company that it's intending to buy, right? And MAC clauses are sort of one of the primary focus points of academic discourse, and the deal point studies that the ABA releases also seem to suggest that lawyers care a lot about MAC clauses and the specific wording. But we only have one case from a Delaware court from October 2018 in which it actually decided that the MAC clause allows the buyer to walk away. Before that, it never happened. Since then, it never happened. So there's a real question about whether what contract drafters currently focus on is really the most important stuff in commercial transactions. And then of course you can do something else with text analysis if you're so inclined. So because it's part of my job talk, and you want to get hired if you hold job talk, you have all these other things you can do. So you can study privacy agreements, for instance. We study climate risk disclosures and company filings. We study the diffusion of language in the Federal Register. And there's also a project in which we study discourse in the constitutional discourse in the congressional record. So how different might be interesting to you. So the basic idea here is, over time, did it become easier to tell a Republican apart from a Democrat simply by the content of what they say on the floor of the House and the Senate? And it is, right? Surprise. In fact, we're now at sort of a historically polarized time when you look at sort of the content. It's very easy for a machine to tell whether you're a Republican or a Democrat simply by looking at what you're saying on the floor of the House and the Senate. So if you use Obamacare, right, we know you're a Republican. And then if you use Affordable Care Act, we know that you're a Democrat. And that has implications because it seems like if parties talk about the Constitution, they basically right now talk very different languages. It's not really dialogue. It's sort of a parallel discussion by both sides. Yeah, but that's it. That's what I have. I'm looking forward to questions if there are any. And thank you very much for listening. Yeah.
For your classifier, so it was just like a bag of words model that you were using. Did you look at the weights of what? Did you take a look at the weights for your bag of words model and just as like a sanity check, sort of see what were the most sort of significant predictors? And
yes, sir. So it's a negative binomial classifier.
Yeah.
And here you see the most important informative features. So. This is actually for arbitration clauses. You can go down the list.
Cool. I'm not a lawyer, so I wouldn't know how to make.
Oh, okay. So just so everyone's aware. So what you don't want with, for instance, because sometimes, in this case it would actually be fine, but sometimes what you don't want when you, for instance, there was a particular problem when you look at if you do text analysis on. Let's say Wall Street Journal versus New York Times editorials, right? Sometimes you want to know sort of, do they write very differently? Do they appeal to different constituents? You don't want to just pick up stuff like the New York Times saying Mr. President and the Wall Street Journal saying Mr. President, right? A classifier would notice, and it would be very easy for the classifier to tell whether you're a New York Times or a Wall Street Journal article, but that's not really substantively what you want to pick up, right? That's why you often look into what the classifier actually does. Word of caution, if you're a social scientist, I see more and more studies which try to interpret these things causally, which try to say, okay, because, this is not a great context, but something like, because you use the word, I don't have a good example, but the important thing here is that you can't interpret those causally. This is just prediction. There's a difference between prediction and causality. We'll have a nice seminar on this next quarter if you're interested. But I'll stop there. But be cautious if you try to assign any substantive meaning to what you're seeing here. Is sort of the lesson. There was another hand. Oh, sorry. Did I answer your question? Do you have...
Maybe just like one follow-up.
Yeah.
Too. So you mentioned that there was like you try like the bag of words classifier, and that seemed to do pretty well. And then you tried like sort of like word embeddings and contextual word embeddings. Not much of an improvement in accuracy, I guess. Okay, so my background is in computational linguistics, and I guess like my a place I might like try to like jump in between and just see if there was any improvement, especially if the bag of words model is doing super well, is one where you're like training on like bigrams or trigrams, like little chunks.
Okay.
And did just because maybe there might even be sort of more signal in like in small sort of like telegraphic phrases rather than just like individual words.
Yeah. No, that's a good suggestion. So what I did was I used a phraser to combine common bigrams, but I didn't do sort of the full sort of bigram analysis that you're suggesting. So yeah, that's definitely something I can look into. Thanks.
I have an online question.
Yes.
So Moritz asks, thank you for this great lecture. Your hand-labeled data in Europe, you'd obtain a sui generis database right on that data set. If you would make a commercial product out of your academic research, would you consider your hand-labeled training data set to be your own property that you could sell to another company in the USA needing data to train algorithms via a contract? And if yes, would you clear the IP rights on the templates owned by the various law firms first through a license? That.
Yeah.
It sounds like
maybe
that's an offline.
I understand half the question.
Yeah. Would you be willing to volunteer your email address for follow-up
yeah,
or
sure.
Twitter or?
So my email address is jnyarko, jnyarko@law.stanford.edu.
Yeah, I'll put it in the chat.
But so for anyone who's thinking using this commercially, creating 5,000 hand labels is sort of super low cost, right? And form selection laws are not hard to identify, so whoever wants to do something commercial out of this particular thing, go ahead. Even if this is for offline, doesn't matter. So yeah, okay.
Hi, I'm Kevin. I'm an alum, and now I work as a software engineer at LinkedIn. And I'd like to ask about sort of broadly culture and process, and whether in this research you came across any outlier firms that were exemplary in their ability to take a draft, say from Sellers Counsel, that didn't have an FSC, and then they had a high rate of uptake, in terms of applying that. And I don't know how you'd be able to, deduce or infer this from the publicly available data, but if there are any indications about cultural practices, maybe like the notices included multiple partners, or maybe they even mentioned the associates, or anything that would tend to indicate like some sort of difference in process or culture that was then leading to a different outcome.
Yeah. So I can only tell you qualitatively a couple of mechanisms that I suspect are relevant, but I haven't tested those formally just because I haven't formalized culture in law firms. But first, so you see some variation between law firms and how they include choice of form provisions, which is this column, right? Now these are much higher than what you saw before because this is subsetting to only contracts where I can identify a law firm. That can tell you one of two things, or two things. So hiring an external law firm might increase the quality of the contract, right? So we have fewer gaps when we look at only contracts where we can identify a law firm, and presumably the others are less likely to have been drafted by a law firm, right? So that's one thing. Or when you hire an external law firm, the stakes are higher, so everyone's more careful, right? And that's why we see sort of more choice of form provisions. But we have some variation. Now, what's very curious, and I presented this on Saturday in front of the ABA M&A committee. So that's basically all the lawyers that I identify here. And the reactions were interesting. And I think the most interesting thing is that there's sort of extreme heterogeneity in how people handle all of this. So, for instance, what White & Case in the UK does is before they include a dispute settlement clause, they send the contract to the litigation department. And the litigation department includes the dispute settlement clause provision. That's White & Case in the UK. So there, I haven't looked at White & Case in the UK, but I would expect very few contracts to not include a choice of form provision. However, even there, not everything is perfect, because what we see there, at least what I heard anecdotally, is they always included arbitration clauses. and then they had one really nice litigation that they won and liked, and then they switched from arbitration to litigation based on one case, right? Other law firms have contracts databases, and sometimes these are actually really carefully monitored and revised with regards to changes in the law. However, what you then see is multiple partners ignoring those contracts databases. So what partners like to do is just tell their associates, get me whatever I did last time in a similar deal. And so even though you have contracts databases, you also have these templates floating, partner-specific templates floating around that are not actually derived from those contracts databases. And sometimes the contracts databases are not well maintained. So a friend of mine was responsible for creating the M&A clause database for one of these law firms. And he was a first-year associate who has never seen an M&A contract when he did this. And that got then used by the company, by the law firm. So just very strong heterogeneity in practices, and also to speak to culture. So another point that seems to vary is a lot how much transactional lawyers cooperate with litigators. Because there's anecdotal evidence that tells us litigators often see this. They say, oh, there's no choice of form provision, or there is a poorly drafted choice of form provision. They approach the transactional lawyers, and transactional lawyers say, we have all the deal is pretty much done, please go away. If we add all that redlining now, you just open the negotiations back up. So there's anecdotal evidence to support all this, but it's sort of not quantitative yet.
And these rates of inclusion of form selection clauses, are these? Does this include documents where you were able to identify that the counterparty had taken the pen on the first draft, or is this the rate of inclusion for final documents that were based on the firm's precedent?
So this is just I'm not sure I understand the question, but I can tell you what this is. This is just basically summary statistics for all contracts in which I could identify a law firm. So Latham Watkins is all contracts where I could at all identify Latham Watkins as participating in the drafting, being mentioned in the notice clause. And then Skadden is all contracts in which I was able to identify Skadden as having drafted.
Yeah, so my understanding from what you said earlier is that you were able to identify
yes, that's not this table.
which final contracts published on Edgar were based on firm precedents versus were based on a template that another firm had provided the first draft of. And
I can, this is just not that.
Okay.
Are you suggesting I should?
Well, yeah, I mean, I think that's what's really interesting, right? Because, like, maybe firms are disciplined about including it in their templates that are bouncing around. But what would be really interesting is to see, for firms that are getting seller's counsel's template that does not include an FSC, what is the rate of their correcting that?
Yeah, so I did that, right? I did that that's a test that you saw when you saw the contracts and so the correction rate is basically, say that again, maybe I wasn't quite clear. So this is, I look at, this is basically a firm that receives a draft without a choice of form provision, and that firm has in the previous year not used choice of form provisions frequently. And this is a firm that has used choice of form provisions frequently, also receiving a draft without a choice of form provision. And then you can see, okay, if I'm a firm that has not used them frequently, 16% chance to see one. If I'm a firm that has used them frequently in the past, and I receive a draft without choice of form provision, I see 19% chance to see one in the final agreement. So the story where I speak up and correct, right? This is not statistically significant, so we have no evidence, at least, to support that story. Yes.
And so, have you? I guess not, but it'd be interesting if you came across any extreme outliers there who had like a 90% rate of catching the fact that
catching. Yeah. Okay.
I mean, that would be interesting, right? Because what are they doing differently?
Yeah.
But it seems like no one's doing that we found so far is doing things differently.
Yeah, I mean, it's interesting. So when I talked to the lawyers at the ABA, everyone said, let's go around the table. Did anyone ever get a draft without a choice of form provision? And I said, no. And then I said, would you notice? You said, good question. I don't know, right? Because the question is then how do you review those drafts, right? And so I definitely agree. It's interesting to look into whether there's someone that sort of always catches those. Yeah.
Great presentation. I had a question about your data set. So I believe you said it was from the SEC and it was just over 500,000 contracts. In similar literature and studies that have looked at contracts, is that number of 500,000, is that larger than past experiments that have been done at this level? And also, are there any other like larger repositories of commercial contracts out there?
Yeah, so what has been done previously is sort of in the hundreds, if at all, because so the studies, the vast majority of studies that you see in law review articles are hand-coded, all of them. So you can never. So for instance, what some have done is draw a sample of 140 contracts across all those years, right? But that limits you in. So by the way, small asterisk. More data is not always better. I wouldn't argue that. But if you want to slice and dice data sets like I do here, right, by law firms and by lawyers and so on and so forth, you usually need a lot of data. So there are studies by Weidemeyer, for instance. I think he has 140 contracts, which are randomly sampled, but then you're very limited in what you can do. Now we see increasingly more studies using this data set. But as far as, if I'm thinking about this, I think there's one study in law reviews, and then the rest is usually business law study, business studies.
Thank you.
Yeah.
Question online.
Okay.
Could you elaborate on the software tools you use to conduct this analysis?
Python, I did that. So I usually do NLP in Python and machine learning in Python, and then for statistical analyses, I switch to R. But and for plots, but you don't have to. You can do everything in Python by now, I think. You can also do much of text analysis in R, but my suggestion would be for anyone who's interested in learning machine learning stuff and NLP is to learn how to code in Python. That's really the only barrier of entry. After that, the whole discussion, much of it happens online, and so you only sort of, the key you need to access all that wealth of knowledge is really just being able to code, which takes a lot of time, but yeah, I think the return on investment is really high if you are willing to make that investment. And I wasn't able to code when I started my PhD, right? So you just need some time, though. Yeah.
So you were telling us about the causal effect or not causal effect of different Supreme Court decisions, which got me wondering, I mean, if it's a null result, then, the sample size gets relevant for whether it's an actual finding or just a null.
Yeah.
And so I'm wondering, I mean, you have a huge data set, but how do you define an independent observation in that? How many independent observations do you have? Is every contract independent in your analysis? Independent observations. Because, I mean, if contracts cluster around law firms, then would you consider each contract an independent observation? Or each law firm, or what's the unit of analysis that you're using?
So this is actually much more, this is a quite complicated question. It's not necessarily for the time series, because time series analysis can take some of that out, because you're fine with sort of serial correlation in time series, because you can try to model that. For this analysis, it becomes a big problem, because here I have contract dyads, and then the question becomes, so the question is always, how much new information do I really get if I see a contract between A and B and a contract between B and C, right? How much new information do I get from the second pair, B and C, that I didn't have in the pair A and B yet? So dyadic clustering is sort of it's something that political scientists just recently noticed, that you need specific methods to do dyadic clustering. And political scientists, because they're usually interested in trade, and in trade you often have dyadic data. So there are particular methods, and so the problem is that these methods have not yet been sort of adapted to big data. I use them on a small sample, so basically clustering on individual contracts, on the contract level. I use them to make sure that it doesn't have a huge effect on the standard errors that I have here, and it doesn't. But for the final publication, I'll redo all of them. It just needs to run a very long time, just because these methods haven't been adapted. But yeah.
Yeah, hi. Have you published your raw data set, just your Edgar crawls, or would you?
The contracts?
Yes.
No, but I can make them available, and I will publish them eventually. I just need to publish this first. But yeah, anyone is also free to crawl Edgar. And by the way, so WRDS, so UPenn, the business school at Penn has all that data. If you, at least if you just want to crawl the links and then download all the data, that's the easiest way to do it. Well, an easier way is to just ask me. But this is up to 2016, right? So if you're interested in 17, 18, 19, and 2020 maybe.
All right, well, if there are no further questions, then please join me in thanking our speaker for the great presentation.
Thank you.